This educational program is intended for the personal, non-commercial use of its listener and may not be reproduced for any commercial purpose without the written permission of Rex Crandall and CALDA. The policies, positions, views and opinions expressed and/or provided herein are not those of the State Bar of California, CALDA, or any entity associated therewith, and are strictly those of the authors or speakers. No representations or guarantees of any kind are made with respect to the accuracy of the written, visual, oral or audio portions of this presentation, and nothing herein should be relied upon to answer any legal questions. The written, oral or visual information expressed or provided herein should not be relied upon in dealing with any specific legal matter. No attorney-client or CPA-client relationship is created by any part of this educational program and related activities. Attorneys, CPAs or LDAs using the information expressed and provided herein in dealing with a specific client or clients, and their own legal matters should also research original sources of authority.
Okay, great. Welcome, everyone. Thank you so much for joining us once again for the conference with Rex Crandall. Let me tell you a little bit about Rex. His firm does a lot of income tax. They also work with individuals, trust and businesses, and real estate in the legal area. They do estate planning, estate and trust administration after someone passes away. They also do a variety of court activities and probate. He is a CPA and attorney and a real estate broker. And he recently published a book called Comprehensive Estate Planning. Don't Leave Earth Without It. That's available on Amazon. So Rex, go ahead and take it away.
Okay, well, welcome to Durable Power of Attorney for Asset Management. We have a lot of material to cover tonight. Some of it is very technical, and you're going to have to follow along and make sure you keep up with it, because I don't want to lose anybody here. So starting out, let's go to the learning objectives. What is it? We're going to learn about what is a durable power of attorney for finance. What happens if I become incapacitated? What happens if I do not have a durable power of attorney and I get dementia? What powers can I give my agent under this document? What are the risks to my assets and beneficiaries for using or not using a durable power of attorney? And I'm trying to bring in real life examples of how this document works. First of all, why do we even have durable power of attorney? Well, what I finally drew, the analogy is there's life and there's death. Okay, that's obvious, but there is a middle ground, and I'm kind of starting to call that the twilight zone. It's between life and death, and it's called dementia. So someone is still alive, they still have assets, they may not be able to manage those assets, and life goes on with their assets and their bill paying and their real estate management and everything else. So that's why we have durable power of attorney. And when a person dies, the durable power of attorney is invalidated. It's no longer functional. And then the will and the trust continue. So first off, I put in the materials, the class materials, quite a few documents that I would like to explain how they work and what they're for. So the first one we have here is a durable power of attorney. This is called California Uniform Statutory Power of Attorney. So this is one that was created by the legislature I am now referring to it as the 4401 power of attorney because that's where it comes up in the probate code. It's a simple form. It could be a do-it-yourself form for clients, family, friends, just the principal and the agent. And you'll notice here that there's not room for a second agent. I always, whenever I appoint any person to work in an estate plan, I have one person and then two alternates. So you could put, you know, one person's name here and then down here put, if not available to act, then the next person, if not available or willing to act, then the next person. So that you're never, we have to go to court for trusts and other documents where they name one person and that person is dead or not available, and the document does not allow any other choice or a mechanism to make a choice. So we have to go get the judge's signature, which is a waste of time. So this uniform durable power of attorney statutory form comes out, and in the beginning it's talking about what kind of rights do you want to give your agent. So the players here are the principal and the agent who is going to act at some point, and the agent is also called the attorney, in fact. So in the statutory form, you can check the box for each one of these items: real estate, personal property, stocks, banking, running a business, insurance, personal family maintenance, retirement plans, tax matters, or what's frequently done is they'll check X. For in, they'll select, put an X in the in box to allow all of those activities to be handled by the agent. And in the probate code, each of those acts has a real long list of activities that are included in that definition. And in terms of tax matters, it says income tax or tax matters, and I have found that the IRS doesn't agree with that statement, and we'll cover what to do about it. So you pick in if that's what you want, and you can have other special instructions, like make sure you collect the rent on my apartment building by the 5th or something, whatever additional items. This particular document is effective on signing. And if you don't want it effective on signing, perhaps after a doctor's signed a letter stating that you're incapacitated, you'll have to change it. And it has to have this magic wording in order for it to survive incapacity. Normally, a power of attorney is revoked or ineffective if somebody loses capacity. The probate code allows you to put wording in the document to transcend incapacity, and that's what the purpose is. And naming more than one agent, two agents, is not a good idea, because both agents, or all three agents, whatever, they have to agree on everything. And they have to take joint action, and they each have to sign documents. I would suggest not naming more than one agent at a time. And here's that clause where you can use copies and reliance. There's two ways to make the durable power of attorney effective. One is by a notary. You sign in front of a notary and they stamp it. The other way is with two witnesses that see you creating or signing the durable power of attorney. I always use the notary method, because if you have real property in the agency for the durable power of attorney, it's going to be ineffective if you cannot record the DPOA, durable power of attorney, at the recorder's office, because real property has transfers that way. So my recommendation is never use two witnesses to activate a durable power of attorney. This particular statutory form comes with instructions, which is fine. And then I want to show you a different form. This is also a California statutory durable power of attorney. However, this model in your handouts is a lot more detailed for people who want to read more about what the rights are. And I'll show you what I mean here. So there's instructions, warning about how to use it and the principle and avoid conflicts. Okay. And it tells the agent that they can only do things for the benefit of the principal. So this particular section has to do with being effective when you become incapacitated. And this one is only effective when you are incapacitated or you want to change it to be an effective now. And granting the powers. Now, this is what I was talking about. In the first one we looked at, all those letters were just one line. In this particular version of the statutory power of attorney, it expresses all the details of what those rights are. So it might make the document more acceptable to a third party. Here's banking, financial institutions, estate and trust. So it gives more clarity. And we also still have the line number N that you can pick for all the above. Special instructions. And this one's different than the first one. This one is only effective on incapacity. And you're giving the agent authority to delegate their task, which is a good idea, because if an agent under a durable power of attorney needs to go out of town for 3 weeks, they can appoint someone else in that interim. The durable powers of attorney, the agents by law have a right to compensation. It's just included in, which is different than trusts, because I find it's odd, but trusts, the successor trustee only gets compensated if it allows it in the trust instrument. And here is successor agent. And then this is the witnesses, which I recommend not using. So it's just another format. You can pick whichever one you feel is more useful for your situation. And let me get to another one. Okay, this one I was real interested in, and I was happy that I found this one. This is a durable power of attorney for financial institutions. And most estate planners are not aware of this. And as we'll get into in more detail, but banks and stockbrokers sometimes won't accept a durable power of attorney. So we'll get into alternatives on how to help that. But this is, I call it the 5204 statutory durable power of attorney, and it's expressly for financial institutions. So it's quite handy, and it might allow it to be more readily accepted by these vendors. And there's no law that says you can't have this one for finances or for financial institutions and the other one that we were just talking about. So I have this available if you would like to use it. There's the notary, and there's no place for this particular one to be activated with 2 witnesses. One thing when you're preparing your estate plan for yourself, your family, or others is look at, let's say you have a large investment account at Charles Schwab, and you're intending for Charles Schwab to agree to honor your durable power of attorney. Well, guess what? Schwab has their own, and it happens to be 14 pages long. So always look at who your vendors are, where your big banks or the stockbroker, Merrill Lynch, some of the others, to see if they have their own proprietary durable power of attorney. If so, I would use it in addition to doing the statutory one. And they may even allow you to file it with their company before you're incapacitated, and that would help in having the institution accept the power of attorney when it turns out that you do become incapacitated. Okay, so the other materials that we have for you is the chapter in my book about the durable power of attorney. And then the last thing that's in the material is the slides for this presentation. So that's all available to you for your use. Now, I want to cover some estate planning basics so you can see where this fits in. When someone gets dementia, what happens to their estate planning documents? First of all, if it's not already active, the Advanced Healthcare Directive allows the agent to talk to the doctors. The finance durable power of attorney will, if it's not already effective, will become effective. And then that's on incapacity, or I'm starting to call the twilight zone. And then after a person passes away, you look at beneficiary designations, joint accounts, wills, trusts, to see what to do with the assets. What is a durable power of attorney? Or in this case, it just says power of attorney. So there are several different types of power of attorney, and it's basically just you, the principal, granting the authority to someone else that they can handle financial transactions for you. And there's fiduciary duties being an agent under a power of attorney. And one of the duties is if you start a transaction, that you're bound to complete the transaction. I mean, you can't, normally you can resign from being an agent or agent, attorney in fact, at any time. However, if, like, say there's a real estate escrow going, you don't have the right to cancel your agency at that time. The durable power of attorney is very good for someone who becomes incapacitated, but there's some downsides to it. And one of those downsides is if the person that you have appointed as your agent turns out to be a rounder and decides to take money from you, this agency is a license to steal from you. And if you're over 65, it would also be considered elder financial abuse. But the problem is sometimes the police don't give this kind of case priority because you gave them the right to handle your finances. So what's required to make a power of attorney valid? Very little. I mean, almost nothing. The date you signed it, signing it, and notary or 2 witnesses. That's it. The agent cannot be one of the witnesses or the notary. And if a person can't sign themselves, they can have two other acknowledging witnesses, and that will make it valid for the person who couldn't sign personally. But there's very little required to create a durable power of attorney. And what makes this document durable? Well, durable has a meaning in this case that the document survives validity when you become incapacitated. So the document itself must contain one of these three wording examples: that the DPOA is not affected by incapacity, or it is effective only on incapacity, or it's effective notwithstanding incapacity. And if those magic words, one of the three, is not in your document, if a person becomes incapacitated, the document's worthless. So somebody acting under as an agent has the same rights to make contracts and bind the principal, contract, make contracts, borrow money. They have a lot of latitude. Can a durable power of attorney avoid probate? It's not designed to avoid probate, but let's look at how it works. Normally, to avoid probate, if you have a trust, you're going to have a pour-over will. If the will is the centerpiece of your estate plan, then the will is not going to avoid probate. So basically, if you have a trust and a pour-over will where you can transfer assets into the trust, then you might be able to, in most cases, avoid probate. A will only speaks at death, and the durable power of attorney can be active now or incapacity. It's void at death. And there is a possibility that you can have your agent under the durable power of attorney transfer assets to your named trust. But your trust and the DPOA must include wording to that effect. But it is possible to have the DPOA being another avenue to avoid probate in the event of passing away in the future. Okay, in the law for durable power of attorney, you have the right to nominate a conservator. So let's say you don't have a durable power of attorney and you become incapacitated. So you have dementia. Well, if you don't have one of these documents, what will be needed is you'll have to go to court and get a conservatorship of the estate. There's two types of conservatorships: court supervised, where the court will either issue a conservatorship of the person or the estate. And the estate just means finances and management of assets. So yes, you should name a nomination of a conservator if it's necessary. It may not be. And the court has a very high standard that they're supposed to appoint the named conservator that you chose, unless it's absolutely against your best interest. So it is something that you always want to do, is appoint a conservator. But having a durable power of attorney, in effect, part of the purpose of it is to avoid a conservatorship. So however, if you become incapacitated and you have the durable power of attorney, as I mentioned, the DPOA is the same almost, except not court supervised, as a conservator of the estate. You even with a durable power of attorney and you become incapacitated, you might need to have a conservatorship of the person. And that has to do with all your living needs, where you live, food, groceries, transportation, all the personal things that are not financial management. So you do need to keep in mind that there are two kind of conservatorships, and oftentimes a durable power of attorney for finances can do a lot of the things that a conservator of the person would be able to do. Okay, so a principal can always revoke their DPOA if they're still competent. If not, then they can't. They have no rights. The key difference between being an agent under DPOA and being a conservator is the courts place a higher duty, a fiduciary duty on conservators than for agents under DPOAs. And the attorney, in fact, always, and the conservator have a duty to act in the principal's best interest. If, say, the agent was doing self-dealing, like getting kickback on a transaction or something, then the agent would be personally liable for not working in the best interest of the principal. So there's a whole list of fiduciary duties in this area, as they also are for trust. When the principal can fire the agent at any time when they're competent, if there is a durable power of attorney and a conservator of the estate is appointed, part of the conservator papers asks if there is one, and the courts will cancel the DPOA. And there's a conservatorship of the estate and a durable power of attorney are almost the same thing in purpose. And some judges, like in San Diego, the judge there will allow a conservator of the person and have a durable power of attorney instead of a conservator of the estate. Now in Ventura County, the judge there, they do not want to have a mixture of conservatorships and DPOAs, so they will always, when necessary, appoint conservator of the person and a conservator of the estate. It's just their judges are given latitude. When you have a durable power of attorney that's effective when it is signed, it's a subtle thing, but at that point you've appointed an agent and you have capacity. So now two people have a right to manage your assets. So there's a little bit of conflict there. It usually is not a problem, but by granting someone an agency under a DPOA, you still have all the rights to manage everything as you did before. Can a conservatorship conservatorship by the estate be revoked, or the durable power of attorney? We mentioned the DPOA can be revoked if you have competency. Under a conservatorship of the estate, you cannot just cancel it. You have to get judge approval. And we're going to talk about, litigation underneath the durable power of attorney in a little bit. If the conservator stops being conservator, the judge will automatically appoint a new conservator, which may not be the case under the durable power of attorney for asset management. Okay, so another thing that happens when somebody becomes incapacitated, in addition to the healthcare directive, DPOA becoming effective, a person's automatically removed as being trustee of their revocable trust because they can't manage it. And however that incapacity is described in your documents. So how can a durable power of attorney help me? You can authorize someone to handle specific tasks. I have people who are really concerned that they get all their bills paid, even if they can't do it personally. You can have them purchase property, sell property, pay bills, handle routine tasks. These are some of the examples that are included: bank deposits, paying bills, filing tax returns, applying for Social Security benefits, delegating powers to someone else. Your agent under a durable power of attorney can do almost anything unless you limit the kinds of transactions. So one situation, say you had a really complicated asset that needed special handling to manage it. So let's say you had music rights, or you had a patent to a certain kind of software that was making millions. You may want to have one durable power of attorney agent for general transactions and appoint one specific agent that is aware of that complex asset. And we have run into problems with music rights and other things in the past. Okay, this is a big deal. The two most common problems when an agent is attempting to use a DPOA are doctors and banks. Okay, so if you have what's called a springing durable power of attorney, which means that it only becomes effective when you get a doctor signature that you're incapacitated. And if that's the case, and the doctors are reticent about signing for incapacity, and frequently they'll drag their feet and maybe not cooperate like you think they should. They're worried about HIPAA laws and disclosure and all kinds of things. It can be a problem where doctors just don't want to issue the incapacity declaration. And realistically, there's no requirement that you appoint or say in your document that a doctor, medical doctor, is the person who writes the declaration of incapacity. You could name the alternate spouse, you could name a trusted family member, and just outline what they need to do in terms of making a written declaration of incapacity. But doctors are not mandatory, and especially if your DPOA is effective when you sign it. Now, the other problem with the DPOAs are banks and financial institutions. We have a bank, and you go in to try to use the agency. The person wants to pay their bills and they're incapacitated now, and the bank says, no, we're not going to allow you to use the account. We're not going to recognize it. The DPOA is too old, 6 years, 10 years ago. How do you know it's still valid? Same thing with stockbrokers. They might not accept them. And at that point, there's a couple things you can do, but the remedy at law is you file a motion to compel. And the motion to compel is to get a court order to require the institution to recognize the durable power of attorney. And I'll come back to that and give you more details in a few moments. Now, you've given somebody a right to do all kinds of things. Can they change your will? California law says no. It's absolutely prohibited. However, your agent can even establish a trust, change a trust, amend a trust, as long as your DPOA and your trust allow for it, and they're not in conflict, that allow the agent under the power of attorney to do that and change a trust, create a trust, edit, change beneficiaries, whatever rights that you would like to have transferred. Can my agent write or change my revocable trust? We just mentioned that the answer is yes, if it's authorized. And under the probate code section 4264, there's a list of things that the attorney, in fact, can do related to a trust that a lot of people may not be aware of. But funding a trust, modifying, revoking. So it is expandable to include those activities. Can an agent under durable power of attorney use my assets? Well, the implicit question here is use my assets for their personal gain or benefit. And the answer is no. The agent cannot use your assets for their benefit. They're required to use your assets only for your benefit. And as I mentioned, if a person uses assets for their own personal benefit as an agent, it's a breach of fiduciary duty. They'd be personally liable, and they may also get legal action against them for elder financial abuse. What if I want to make a gift to my agent? Well, the probate code, especially, it has restrictions. If you make a gift to your agent, it might be suspect of undue influence. So you want to make it really clear and specify what you're doing. And because the agent would be the one giving the gift that is expressed to themselves. And you may want to talk to a lawyer before you try making a gift to your agent during your incapacity. You could change it to have the gift come from your trust or your will. That would be fine. It doesn't have to come from this particular document. Is it safe to use a Dpoa? It's as safe as the person you appoint if they're trustworthy and competent and follow instructions. If they're not, then it's not safe at all. They can access all your accounts. It could be a license to steal. And one of the things with trusts and probate, we always have the right to get a bond to protect against the trustee taking assets or protect against the executor taking assets in a probate. But in a durable power of attorney for finances, it's really difficult to find a bonding company who will bond the agent in this circumstance. And as I mentioned, because you gave that agent the right, we have found that local police are not overly enthusiastic about helping you or pressing criminal charges because they say, well, you gave them the right and they can deny it, and you might not get the kind of help you would expect if somebody took $600,000 from your accounts. Can I appoint more than one agent? Yes, but I suggest you don't do that because both agents have to be in agreement for every transaction. And that is difficult for every transaction. Sometimes people will say that, oh, my two kids, I don't want to hurt anybody's feelings. Don't worry about it. It's much better if you just appoint one agent and two alternates. If the original agent is unable or unwilling to serve, then the second backup one can serve, or the third backup can serve as the and by having them act as agents in succession, that's not really appointing more than one. It's they're not at all, there's only one agent at a time. Can you appoint a business organization as an agent, attorney in fact? The probate code answer is yes, but I would strongly suggest you don't do that, because what financial institutions do is they won't recognize the organization because they're worried they don't know who in this corporation with 10,000 employees, who's making the decisions. So if you do name an organization as the agent, name the organization and the person's name personally. And don't forget to add an alternate and an alternate to that. There have been cases where everything was set up properly. There was an organization named as the agent, and the employee's name who was going to do it was listed, but then the employee went to work somewhere else. And then the principal had a problem because nobody would accept that power of attorney anymore, and there were no alternates, so they had to go to court to get another one appointed, which is a waste of time and effort. If I appoint somebody as an agent, can I still make my own decisions? The answer is yes, especially if it's the power of attorney is only effective if you become incapacitated. It does create confusion. If you make your durable power of attorney effective now, then you and the agent have the right to manage your assets. But in practical situations, it doesn't cause a problem usually. When does my power of attorney go into effect? When you decide it does. You want it to go when you're incapacitated, you want it effective now. Some people are afraid to give the durable or the agent authority now. And I came up with another idea kind of in between. The choices normally are you make it effective now on signing, or you make it effective on incapacity. And I mentioned you don't have to have doctors for determining incapacity. But this other idea is you make the durable power of attorney only effective on incapacity, but then have another paragraph that says that after 3 years, it's effective right then without an incapacity declaration. So it pushes it into the future and then becomes effective. It's kind of halfway between now and incapacity. How long does a power of attorney last? Well, I'm kidding my clients when they ask this question. I said, the durable power of attorney lasts as long as you do. When you expire, this document expires. It's that simple. And then you move on to other estate planning documents. You can put in the documents that it's only good for so many years. You have complete latitude in drafting contents of the Dpoa. As I said, that durable powers of attorney are canceled at death. The only jurisdiction I'm aware of is in Switzerland. They have a durable power of attorney by statute that says it is effective after death. So the law says it does work. But what the Swiss bankers actually do with it is when somebody tries to use a durable power of attorney beyond death, the banks freeze the account and then force the agent to go get some type of probate court order. So it ends up not working beyond death. Where can I get a durable power of attorney form? Well, you could get it from any place, a bookstore, online, the statutory form, the probate code section for the the one that is used most often is Probate Code Section 4401. You can use a pre-printed form. If you want the finance for financial institutions, you go to Probate Code Section 5204. And so you can, these are readily available forms. So you need to decide on what assets you're going to have the person manage, and also perhaps directions on how to manage. If there's some confusion, seek legal advice before you sign it so that it fits within your objective and is designed specifically for your own needs. How do I know if the power of attorney is valid? Well, as I mentioned, notary, it has to be dated and signed. And if it's durable, you need to specify how that incapacity is determined, doctor or someone else. So I've never seen a durable power of attorney be declared invalid. And there's an interesting thing in the law about durable powers of attorney, in that the court cases, normally in an area of law, there's hundreds and hundreds of court cases. Well, in the Dpoa area, there's only about 5 cases that have litigated the durable power of attorney for finances. And I think the reason is, when you start litigating under this form, the institution requires a conservatorship, and the litigation ends up being conservator litigation, where all the law is. Another thing I wanted to point out is that if you use the statutory form and the bank or broker does not honor that form, they don't give you access to the accounts. If you bring a motion to compel, the bank or financial institution by statute must pay your legal fees for being unreasonable and not honoring the document. Can I have a durable power of attorney and later the court appoints a conservator? Yes. It's part of the conservatorship paperwork that you file that discloses that you have a Dpoa, and it can happen. Normally the court will cancel the Dpoa as part of the conservatorship. Okay, if you're the agent, how do you sign? So in this example, Mike and his wife, Catherine, and she's been appointed the agent, she signs Michael by her name, Catherine, attorney in fact. Another way is she signs his name, Michael, under a POA, or she signs her name and then puts as attorney in fact for Michael. So it's pretty simple. You're just letting the reader know that you are not the principal. I mentioned that IRS doesn't really honor durable powers of attorney, and that is true. The IRS wants the person to use a Form 2848, power of attorney. So nothing I can do about that. Most people don't think to create a IRS Form 2848 as part of their estate plan. But if a person's sliding downhill towards incapacity, that might be something you'd want to consider. And then when someone takes over for an incapacitated person, IRS also has a form, Notice of Fiduciary Relationship, that you're now in charge and send all the IRS mail to your address, not to the principal's address. What can be done if there's a dispute about the power of attorney? If you're of sound mind, you can cancel it. And there's a long list of people who can file lawsuits related to durable powers of attorney. here's the list. And it's it's almost humorous the way that they wrote this law. So what we're talking about here is, let's say you have an uncle and he's got an attorney in fact under durable power of attorney, and other person thinks there's some problems going on, so they file a lawsuit against the agent. All of these people can file lawsuits. The attorney in fact, the principal, the spouse, a relative, a conservator, a court investigator, public guardian, personal representative, trustee, successor in interest, which is a beneficiary, a person requested, or any other interested person or friend of the principal. So it's a huge group of people that can target the agent for litigation. And there's a way to remove those people's rights to be able to sue the agent. And that is, you hire a lawyer and they prepare this statement that I am authorized to practice law in this state. The principal was my client. I advised him all of the good and the bad about the power of attorney. And with all that knowledge, they decided to execute it. And then you can eliminate people from that list. If you do cancel or change your DPOA and you have recorded it already, you should record a revocation and the new one. You obviously have to notify your agent, and anyone who relied on your document before. And if you cancel a text version of the DPOA and you have some vendor forms outstanding, you need to cancel and update those too. It sounds ironic, but an attorney in fact is not attorney at law. So let's say there's a claim against a third party. Your agent under the durable power of attorney cannot file a court case and go after the third party themselves without a lawyer. And if a conservatorship is needed, the agent cannot file under the rights of a DPOA to create a court supervised conservatorship of the estate. However, if a conservatorship of the estate or person is needed, a family member or attorney with the family can create that type of case. So if the agent's having trouble getting the agency recognized, you can file a petition to compel. And if you use a statutory form, the bank is absolutely going to pay the legal fees. And if you use a free form DPOA, the judge has discretion about awarding attorney's fees for the vendor unreasonably not recognizing the agency. Sometimes banks and brokers will say the document's too old. They'll say that, oh, it looks like it's forged. And they might say that, oh, we at Charles Schwab, you have to use ours. We don't recognize anybody else's. And the agent can go to court and ask the court for confirmation that they're entitled, and get the court to order the acceptance of the form. We've already talked about the problems of getting it accepted. There's another procedure that can be used, and that is a third-party bank or financial institution won't take the durable power of attorney because they think, well, how do we know it's not revoked? Well, the agent can hire an attorney who can create a statement that says it's under penalty of perjury that the agent knows that they've not gotten any notice of revocation or change of the document. And in that case, when that's presented to the vendor, the law says that that statement, under penalty of perjury, that's notarized, is conclusive proof that the DPOA was not revoked. So you're going around an objection from a vendor. And as I showed you originally, the 5204 statutory financial institution form is available to you. What types of powers of attorney are there? So these first two are not estate planning documents. A general power of attorney, you just want somebody to manage all of your stuff, and you just grant them the attorney, in fact, have the magic words on the document and allow them to manage things for you. Then there's a limited power of attorney. You might grant that to someone if you're in the middle of a real estate transaction and going to Europe for 4 weeks and you don't want the deal to fall apart. You can give someone a limited durable power of attorney just to complete that transaction. And we've already talked about durable powers of attorney and springing after a doctor or someone else's incapacity declaration. You need to be careful of an agent that is given the rights to change or designate beneficiaries. And it could be a real problem, especially to the beneficiaries. But you just have to be really careful. And if the person is, let's say the senior over 72 years old is required to take minimum required distributions or get penalized, the agent is bound to continue to do that. At first blush, authorizing your agent to make gifts sounds like a bad idea. But if you think it through a little more, it might be an okay idea. And that is, let's say you're trying to qualify for Medi-Cal and the person's health is going downhill on a steady basis. And Medi-Cal, if you have too much money, they will not pay, like say, for example, the $6,000 a month for a skilled nursing facility. Well, if you authorize and you're incapacitated and you authorize the agent to make gifts for you, you can gift away the money, and perhaps 3 years later or more, depending on the law and the Medi-Cal compliance rules, which you have to be real careful of, then if and when a Medi-Cal application is filled out, that you meet the criteria because, for example, the gift was made more than 3 years ago, and then Medi-Cal will pick up the skilled nursing costs because the person doesn't have any money in their name. Updating documents, I would suggest every 3 to 5 years, create a new durable power of attorney. It's small cost compared to what a conservatorship will cost. And your loved ones will likely think it's a minor miracle that you had the foresight to know that you should do this, and when incapacity comes, you don't have to have that expensive process. In summary conclusion, no one can predict when they're incapacitated. You need to have somebody manage your assets in this area between life and death called incapacity, dementia, the twilight zone, and the cost is very reasonable to create for the benefit that you get. So that's the main part of the program today. I'm going to open it up for questions here in a moment. I would like to invite you to look at our YouTube channel. We have a lot of educational estate planning videos. The channel name is California Estate Planning. And you might look at and consider subscribing to our YouTube channel. And at last, I have included the information. We have this book that I've written that's available on Amazon if you are interested. So that is the material that I wanted to cover, but I'm now eager to find out if there are any questions, maybe things I could clarify.
Yes, there are, Rex. So
Okay.
first question is, what's the difference between a uniform statutory power of attorney and a durable power of attorney?
Okay. The uniform statutory power of attorney comes under Code Section 4401, and that form is effective on signature unless you edit the form to make it effective on incapacity. And the uniform statutory power of attorney can be springing. It's designed originally to be effective now. So the only difference between the two concepts is when you say durable, it means it transcends incapacity, and whether it's effective now or it's effective on incapacity, the durable language that says you intend this to survive your incapacity, that makes it durable. So it's just that wording.
Okay. Can a wife who has a durable power of attorney use it to create a revocable living trust and will to leave property to each other and list their children as alternate beneficiary?
Okay. If you're working with a durable power of attorney, and that's the question, you can have wording in that document that says you are allowing them to create a trust, revocable trust, and give them parameters on what they can do in terms of naming beneficiaries. If the trust is in existence or going to be in existence, you want to have the terms of the Dpoa, the rights being expressed, are in harmony with the words that says it can be amended in the trust document. Now, I mentioned in the text that you had asked about the agent creating a will for the principal. The law absolutely clearly says no, the agent cannot create a will.
Okay. Can a POA agent be a beneficiary to access to a living trust?
Yes, a agent under a durable power of attorney frequently is a beneficiary under another document called a trust. There's no problem there. It's the principal making their own decisions. And if they want, let's say an oldest son or oldest daughter to be the agent, fine. If they're a beneficiary, fine. There's no conflict. One conflict that comes in fairly frequently is a caregiver. You put on caregivers getting a large inheritance and it's suspect from the get-go. But the way you phrase the question, there's no problem.
Okay. When is it okay to delegate POA agent authority to someone else? When is it okay for compensation to an agent?
Okay. First of all, delegation, the document can say in it that it can be delegated temporarily or permanently to an alternate. And I recommend never putting in just one person's name in to act for you. Put in one and a backup alternate and a second alternate. And you can give them the right to delegate temporarily or permanently. Compensation, it's interesting, under the probate code, an agent under a durable power of attorney automatically has a right to compensation, which is not the same as a trust. The trustee only has a right to compensation if the trust instrument says they do. So I think that covers it.
Okay. If a POA, if a DPOA and the person becomes incapacitated, can the agent transfer the real property out of the trust? If yes, can they transfer to themselves even if they may not be a beneficiary?
I have my radar going up that there might be a legal problem here. There's two questions. I've already answered where if you have the terms of the DPOA say you can amend a trust, and the trust wording also confirms that, you can have somebody amend the trust. I really dislike the way that the question was presented, because it sounds to me like the agent is changing the trust, diverting the plan of the principal, and having maybe cutting out other beneficiaries and giving money to the agent. So the way I'm interpreting the question, I would definitely say to avoid it.
Okay. Are you, let's see. Nola's power of attorney has a question. Would you want your agent to be your conservator? Is it necessary if they are the successor trustee?
Okay, we have multiple documents going here. Your durable power of attorney, you can name a conservator and the court should appoint that person unless something's way off. In terms of being a trustee, there's no interaction. The trust document expresses how that is going to take effect. And if you have an agency under durable power of attorney and a conservatorship is created, the court might terminate the durable power of attorney. But keep in mind, on conservatorships, there's two types. We have conservator of the person, and the durable power of attorney for finances or asset management has nothing to do with conservator of the person. The conservator of the person controls living, clothes, shopping, recreational, sexual contact, food, lodging, and all the personal stuff, but not the money. The durable power of attorney or conservator of the estate is duplicative of the durable power of attorney, except that the court is involved. So I hope that answers the question. If I didn't answer it, then ask it again.
Okay. What do you think of for trust version of the DPOA? Is the statutory DPOA not as acceptable to financial institutions?
Okay, so for trust, as many people don't know, is an estate planning software provided. It's got two different names, for trust and also online version called Adapt. And it does create a durable power of attorney that is all text. However, you can check a box in for trust and have it come out on the statutory form. You have an option. And what I'm thinking in terms of the statutory form, I like the idea that if I use the statutory form and I have to go to court because they won't take it, the statutory form law says that the bank must pay the attorney's fees. And that gives you a leg up on negotiating with the bank. You say, either you take this or I'm going to take you to court and you're going to pay my legal fees. You decide. So at the present time, I'm leaning more towards the statutory uniform durable power of attorney, the one under section 4401, and you might even back it up with the other one that I mentioned that for financial institutions, the 5402 code section, durable power of attorney.
Okay. All righty. Let's see. Can a financial agent sign the IRS form the IRS requires of someone that is incapacitated?
Okay. The answer on a tax return, yes, the agent under durable power of attorney can sign it. The way we have them sign it is the principal's name by agent's name, attorney in fact, and it will go through. I've never seen one bounce. And notwithstanding the fact that this document that we're creating in all text is not going to be accepted by the IRS. You have the right to manage. So signing a tax return, I don't see a big problem as long as you disclose that you're an agent. I would also include the IRS Form 56, because now you're disclosing to IRS that you're the fiduciary. But if it gets into an audit or you're needing documents from the IRS, they're not going to recognize anything except the IRS Form 2848. And if it's necessary and you don't have it and the person's incapacitated, you might have to go to court to clarify it.
Okay. Should POAs be recorded with the county, and should we give a copy of an immediate DPOA to the bank or financial institution to keep on file?
Okay, so I'm going to treat that as two questions or three.
Yeah.
I do recommend recording the durable power of attorney, but if you do that, don't put a lot of personal confidential stuff in it because it's public record. And some financial institutions, I know there's been agreements with attorneys and banks where if the DPOA is recorded soon after creation, the bank will accept it because they are not worried about incapacity or dementia. And trying to think of the other parts there. So I do recommend recording it. It's not required. It's a good idea, and it might make it more acceptable because the durable power of attorney is not usually created in a format for the county recorder. You're going to have to put a cover sheet on the top of the DPOA, which usually has a line across and room for the recorder to have their stamp. And you just have to look up the cover sheet requirements. But I do think it's a good idea. But you'd also talked about financial institution. And I suggest everyone that is creating a durable power of attorney where they have one financial institution that's handling a lot of their money, go online, see if they have their own form. You can save a lot of trouble if you use their form.
Okay. And then the other question, oh yeah, about the DPOA, once it's executed, should you give it to the banks and financial institutions?
Oh, okay. If they'll take them, some banks say, we don't want them. Why are you doing this? If it's not effective now and it's only effective on incapacity, I don't think that the bank is going to really want it. First of all, I would use their form. Second of all, you can try to give it to the bank if it's effective now. Banks are really picky and they're so hung up on their own forms. I would be willing to bet that the bank is going to want you to fill out something else.
Okay. All righty. And let's see. Why is the fiduciary duty higher for conservative than for the agent in a durable power of attorney?
That is by statute. And whenever you're involved in a court and you have court supervising an agent or a conservator or a guardian handling someone else's money, the court is right there and they're on your back all the time. And it's statutory that the fiduciary duties are enumerated in more detail for those kinds of court cases. In a durable power of attorney for finances, you're not in court. You are acting independently without court supervision. And so only a limited number, not the full plethora of fiduciary duties are applicable. So the conservatorship is more statute driven, and the durable power of attorney for asset management allows more flexibility.
Okay. What happens when a person names an agent for the POA, but while incapacitated becomes paranoid and no longer trusts the agent? Can the incapacitated person remove the agent even though he or she doesn't have the capacity to manage their own financial affairs?
The answer is no, but that's not the end of it. An incapacitated person has no right to do anything related to contracts. But the way that someone would handle this is the incapacitated person asks another family member to create a conservatorship and take the job away from the agent, or beneficiary or agent requests an accounting. Remember that long list of people who can sue under a durable power of attorney? Almost anyone. So that would be the mechanism where the paranoid individual can have a family member step in and start trying to undo it, even though the principal cannot.
Okay. And then question not from class, but in regards to a living trust, husband has his own trust, later gets married, then amends and adds his wife as a trustee. Years later, they divorce. Should he amend his trust again or make a new one?
This is not a class about trusts. This is a class about durable power of attorney for asset management. And in the context of this class, if you've appointed an agent and they're a spouse, you get divorced, it voids the contract by divorce. Okay. But even though it's void, if you get remarried, it reactivates the durable power of attorney. Now, in a trust, anytime there's spouses and a divorce, I would suggest correcting the problem within the document. And there are statutes that will void certain gifts based on a divorce, but that's not the subject. Trusts are not the subject of this class.
Okay. What is your YouTube channel?
The YouTube channel is California Estate Planning.
Okay.
And we have probably 20 or 30 videos. I made another one this morning. We're trying to include a lot of different angles for estate planning.
Okay, and then one last question. The agent can sue in pro per or is mandatory to hire an attorney?
That slide that we had that has said an attorney in fact is not an attorney at law. And the answer to the question is no. The agent cannot sue a third party as an agent in pro per. They would have to hire an attorney to sue a third party.
Okay, that is all of the questions.
Okay. Well, those were some interesting questions, a little tougher than I anticipated, but we got through them. And I want to thank everyone for attending the class. And if you have questions, that come up, you can call our office. We'll be happy to answer questions about, little details about the class or other thing. We make that available to students that have taken our classes. So just keep that in mind if a situation comes up.
Okay, great. Thank you, everyone. See you next month.
Okay, very good. Bye.
Bye-bye.